Yes, now it is. Now we can start. Thank you very much for coming today, this evening, to this webinar, this Q&A session, FIDIC contracts in Georgia and Armenia. Today we will have 4 speakers. First of all, it will be me, Andrey Artyushenko. I'm from Kazakhstan, construction lawyer and arbitrator with the 23 years of experience in Kazakhstan and in post-Soviet Union countries with construction contracts and construction arbitration. I'm the member of the FIDIC team developing the subcontracts right now, and also I'm a managing partner of the Artyushenko Partners boutique law firm from Kazakhstan. Then let me introduce Nina Tsaturova. She's from Georgia, Director, Head of Legal Intelligence Solutions, LLC. She is the FIDIC certified adjudicator and trainer. She's Head of Contract Principles at FIDIC Academy, and also ACEG Management Board member. And also she's the DRBF country representative in Georgia. Irakli, Khergiani, hello. Nice to see you here as well. Irakli is from Georgia. He is acting country director representative at Dowa Engineering, and he is ACEG president now. And the 4th speaker, Karin Arustamyan, he's from Armenia, a construction contract manager, management and tender expert at Technocrat Legal. He's practicing lawyer in construction and management under FIDIC contracts with experiences from 1995 in Armenia, Kazakhstan, Georgia, Russia, and other nearby countries. And also he's our Artyushenko Partners law firm external expert. So welcome, and without any losing any time, I suggest yes, Karen.
Yeah, I would like to add that for non-Georgian participants, that ACEG is ACEG is a Georgian Association of Consulting Engineers. There is a FIDIC member association. So
that's right. That's right.
Do not know this. Okay.
Yes, Nina and Irakli are representatives and very active representatives, I would say, and they are participates in a lot of different events developed by different companies. Thank you very much for participation.
And one more thing, every time you represent me, my experience goes bigger and bigger. I started in construction in 2006, 1995, Gandhi.
Okay, it was provided by you. I'm sorry, it's copied.
Yeah.
Okay, let's move on. Answering your questions. Let's see. First question, which we have got in the list is why are large projects from lenders like ADB and WB still handled by FIDIC 2010 and not by the FIDIC 2017, 2022, 22nd versions, where risk management is more even and the process is more elaborate to avoid the contentious relationship between the parties. Irakli, please, can you help us with this question?
Hello. Hello to everybody. Thank you for a nice presenting of the speakers. Thank you, Andrey. One more thing that I want to add, except the president of the association, about me, I'm also a FIDIC president list dispute board, adjudicator.
It happened several days ago. That is why it's not here.
No, that happens like, it's like almost a year.
Right now. Okay.
Yesterday.
My mistake. Next time.
No problem. That's fine. So, what regards to the questions that why are large projects from lenders like ADB and World Bank still handled by 2010? So actually, before the formalization of the contracts of 2017, the new tenders right now, let's say a couple of months ago, almost a year, the new tenders in Georgia is announced by the 2017 edition. Not all of the banks has still adopted the 2017 version, but the World Bank, the tenders that are announced in Georgia by the financed by the World Bank, is already on the 2010 edition. And several other financial institutions like EIB has also adopted the 2017 versions. There are mainly at this stage, these days, I think all of the IFIs had adopted the 2017 edition of the contract, and from now on, I do believe that most of the banks are following the contracts with a new edition of the FIDIC contract. If we want, we can discuss further more on the difference between 2017 and 2010, which is the formal 1990 version.
I believe we will wait for this question if it will come. I will just add from our practice for the last 8-9 months. We've been participated in 3-4 different projects, and every time EBRD are asking the client, the employer, to choose the form of the contract. And
Yes.
usually the consultants provides the proposal to use this or that year, exact year. And in our practice, we proposed 2017, and they are using 2017. It is because of the lack of the practice, and we truly said to our client that we do not have experience with 2017 for those time. And truly to say, it is different, yes, but it is more interesting, better, and we will get some practice from it. And they agree.
Yes, I do believe that 2017 covers more detailed several issues on the contract, which has not been considered in the 2010 version. But still, there are a lot of how to say, details that it has to be considered and really well focused on it. On the comparing of these two types of contract, Nina is an expert on that. We always have a very hard discussion in the office regarding which one is better. But this is a common right now in these days. So everybody is discussing which forms of contracts are better, or is it correct to continue with 2017, where the opinions are divided quite a lot.
Okay, let's move on to the second question. Thank you. What are the possible means to increase the FIDIC contract governance in Georgia for various contractors and clients, to increase the popularity of FIDIC and subsequently increase the number of FIDIC specialists in the country? Nina, please.
Thank you, Andrey. First of all, thank you for inviting us. Moving to the question, I think it's quite actual and interesting question with regards to Georgia, because nowadays, more and more from the association, we are trying to have more trainings during the year on different kind of topics. And since last year, I also became the FIDIC accredited trainer. So now the association, together with the association, will try to propose the trainings in Georgian as well. I think it will be a good opportunity for the specialists not speaking English to get the knowledge about the FIDIC. So we have very interesting plans for the upcoming year. So stay tuned with the association.
Nina, if I get you right, means that the main issue is the knowledge of the FIDIC itself, how to manage it, how to work with it. But maybe some other problems. I mean, maybe from the government point of view, is it understandable or still the same non-understanding on the?
Yeah, you mean approach? If the government, if the knowledge of FIDIC from the government officials is better than, I would say definitely yes. I'm speaking about Georgia. You may speak about your countries, but Irakli will agree that the knowledge that the government authorities have right now on FIDIC contracts is much better than it was in the previous years. So we are developing in a very good pace, I would say.
I can add a little bit on it. In Georgia, the FIDIC contracts are from 2000 years, let's say around from the 2000. There are, at the beginning, we had a really difficulty from the governmental part that they do not really understood the FIDIC contract, what that is, what is a dispute board, what is a determination, why this strange guy that we are hiring, the engineer, he's instructing the employer to do something, or he's advising the employer to do something. There was a lot of misunderstandings. But nowadays in the region, which I see, and we are involved in a lot of projects as a dispute board, as a client representative, as a contractor representative, it depends. And the Georgian employers, I mean the Ministry of Infrastructure and all the subsidiaries, and mainly in the ministries of all of them, they have a good knowledge. They have a good knowledge of FIDIC. They have a good understanding. They do know what the dispute board is. They do agree with the dispute board things, and everybody agree that the FIDIC contracts are the most proper way to develop international projects, to increase the market, the competitiveness on the market based on the international firms. And of course, the dispute resolution, which has been offered by the FIDIC, is the cheapest way to avoid the arbitrations and a lot of long time losing procedures.
Thank you. Thank you. Maybe Karina will add something about Armenia.
I would like to add to the things that said the colleagues. Of course, for the Armenia is the same, so making the FIDIC contracts popular in Armenia. So everything the colleagues said is applied to us. But when I'm speaking about and thinking about using FIDIC, I always remember those old days when we started to use mobile phones. So it was a very strange thing when you saw a guy using phone on the street. You didn't understand that, why he spent so much money for this, why he walked along the street speaking by phone. But when everybody start to use, it happens that nowadays we cannot deal without mobile phones. So the same with the FIDIC. As much people around you use it, as much people around you has experience of using it, the more you yourself will feel that it is a good thing, that the people around you, they also have their opinion, and I'm sure that FIDIC books is much more better than any other construction contracts. So this is this is how it shall become popular by using. So for Armenia, we use here FIDIC contracts mainly in internationally financing projects, which the government is somehow use it compulsory, but it also brings to people get acquainted with FIDIC. They understand what is it, what are the benefits of using it, and I have nowadays I have a couple of examples of using FIDIC books in private projects. And this choosing of FIDIC book was not compulsory as in case of international financing. So it becomes more and more popular, and the way of making FIDIC more usable, it is just using it.
Okay, thank you very much.
Can I add, colleagues?
Mariam.
Good evening.
Mariam.
Good evening. Sorry for joining late.
We know each other.
Yes, we used to work together with Karen. I used to be with the state institution for about 8 years, and now I'm currently working for the contractor. But with my experience of working with FIDIC contracts, as the colleagues mentioned, first of all, it is the capacity building. And second of all, I may assume that the case is similar in Georgia as well as in Armenia. There are some discrepancies in the local laws and regulations and in the FIDIC. So this is one case. For example, while implementing the project, it was quite difficult for the Armenian authorities to understand the notion of IPCs, for example, that was one issue with the payments that we had. But I do agree with Karen that understanding and using FIDIC comes with starting to use it. So if I'm not mistaken, Armenia started to work with FIDIC back in 2009, 2010, when the first projects of North-South started to be implementing. And now it's mostly the states, the government that signs FIDIC contracts for international projects. But I think that both the private sector, the public sector, as well as the financing banks should invest in capacity building, spreading knowledge, and as well as preparing professionals to work with the contracts.
Thank you for your comment. Thank you very much. We should proceed. And while we are answering some other questions, I am just posting one information in the chat. I will briefly describe this upcoming event a bit later. But we have the third question. Can the engineer issue variation orders without employer's approval? The employer, being the financier of the project, would generally want to authorize any change that could increase the project budget. How FIDIC articulates such procedure of employer's approval for variation orders? Irakli, please.
Thank you once again. I will try to make it short, because on this issue I can discuss like a day, whole day. But let's say the client's representative is the engineer. Right now, according to 2017, it's clear that the engineer is a client's representative, employer's representative, so to say. And with the engineer, there is a different type of contract. Let's say the white book, so to tell white book. In my practice, I had contract experience where the engineer could give variation orders, issue a variation order without the approval of the employer within the gap of 5% of the total contract amount. And there are in the other type of the contracts where in particular condition is stated that the engineer cannot issue a variation order without the approval of the employer. So giving that kind of gap, based on my experience, is giving the project far more flexibility and faster reaction. In case of the engineer has the authority in the contract, consider that according to the contract is allowed, the engineer should issue the variation order. But in the particular condition, it's always like restricted, or it's giving the high gap of, let's say, he can issue a variation orders on the cost of 5% or 0% or etc. etc. I have seen several types of contract in the contract, so to say. But approval of the variation order is under the priority of the client. Of course, the client employer should approve the variation orders in the mainly contract, in the practices like this. But not always, this always takes a little bit far more time. And at the end of the day, the project suffers on the timely decision or the decision-taking issues. So according to the contract is allowed, but mainly in 99%, the employer is restricting that on the particular conditions of the contract.
Thank you for your comments. Good.
Karen,
please.
Yeah.
Please.
So these authorities of the engineer. So if I was a contractor, any variation issued by engineer, I will ask the engineer to present his authorities for this, because we know that the engineer is not party of this works contract, and they have another contract with the client with the authorities written there. Of course, part of these authorities are reflected in the main contract for the contractor to know what are the authorities. but not all. So you know, if I found some variation being a contractor, if I meet a variation from an engineer, which is not more looks like good for me, I will ask for the engineer to present his authorities under that contract between the engineer and the client.
Okay, good.
What do you think?
On our practice, we have seen such approach as well. Usually, in particular conditions, as Irakli said, there are some portion of the money which is allowed to issue without any employer's approval. Irakli, what would you say?
There is, as I told, this experience that there is allowance, there is restriction, but the position that you're mentioning doesn't really give us anything. From my point of view, I do not really need any justification as a contractor that the employer has issued the variation order.
Yes, you're right, Irakli. If this variation and anything, any action from the engineer is for the benefit of the employer, and if the employer also thinks so, they will agree saying that, okay, yes, he had this, but it's just an approach.
Yes, I maybe I misunderstood you, sorry. But issuing the variation order, the engineer has the right to instruct for anything. So according to the contract, you have to do it. If you agree, okay. If you do not agree, then you have the right to claim. Yes, it's the most simple.
You're right. You're right, but
discussion. That we will not enter into the deeply discussions and so on and so on. Mainly is this way. But in reality, what happens that engineer is giving to the client, based on my experience, is giving a recommendation for the issuing the variation order for the contractor. Yes, let's say there is something missing in the project and so on. The engineer knows about it and he's trying to be proactive and asking the employer to issue a variation order, to give him the right to issue the variation order. And afterwards, whenever me as a contractor, in case of I receive the instruction for variation order, for me, it doesn't really matter. Did that has been issued by the employer or it has been issued by the engineer? For me, it's an instruction from the person who has given the authority to do that job, so I'm obliged to do it. So that's the in general, so to say.
Okay.
Thank you
Propose to move on. We can discuss it maybe on the meeting we will have in the end of April. Okay. Next question: do you have centralized governmental support for the education of new FIDIC specialists? I believe it's misprint. Nina, maybe you can add something here.
Sure. Sorry, I have some problems with the camera. If I understand the question correctly, maybe who posed this question may add something. So you mean if there are some governmental programs for the education of the FIDIC specialists, right?
Kirill, maybe you with us. Can you please turn on your mic and add Kirill Lanovenko asked this question.
I'm very sorry. Sorry. I have to do it from my home and my child was here. Never mind.
No problem. Kirill, you here?
Can you hear me?
Very bad. Do you have?
My apology. Can you understand me? Let's say so.
We hear you, but not very well. Okay, let's try.
Okay. So my question relates actually to education itself. First of all, whether the governmental is there governmental support or not. The second issue there, if there is a need or maybe there is an initiative right now. Well, despite the fact that we already know that the King's College have implemented the program, FIDIC program in London, do we have maybe some kind of a different example which we can, for example, use in the local university? This was my question. I bring my apologies.
Thank you.
Thank you, Kirill. I now understand what you meant. In Georgia, the Georgian Technical University also wanted to adapt the FIDIC course within its educational program, but so far it's not developed yet. From the other countries, from what I know, in Uzbekistan, as I know, in one of the universities, there is a FIDIC course implemented already. Maybe, Andrey, I know that you are involved in this, and maybe you can talk about this. From like a government support, it's difficult to talk about this because actually the government of course finances the courses, but for its own employees, not like in the universities or in any other manner. That's what I know on this.
Okay, I can add something on this matter.
Sure,
What
sure.
about the support of the government of Georgia for implementing or for preparing the new experts also? As we all know, in most of the funds that the governments are receiving, there is always a capacity building item in the loans. So basically from this, the government bodies or structures or ministers are financing the training courses for the preparation of the new experts. What's our association plan is that we are soon enough are going to discuss with several universities to develop something like an advisory or understanding course in the university with a negotiation that it will take quite a difficult time because we need to to discuss with the FIDIC in Geneva and the university and all of that stuff. It takes a huge job and we need to develop the program. Actually, we are lucky that we have a Georgian certified trainer, Miss Nina, and she can work on it. And as she is also the chancellor of the FIDIC Academy, so she will support on that. So we are working in Georgia to develop that kind of course in several universities. We are stopping our choose on 3 universities at this stage, and I hope until end of this year we will develop one of the programs in one of the best proposed universities here in Georgia. It will be maybe in Georgian and in English as well.
Great. Karen, do you have something in Armenia?
Something for Armenia, yeah. So no government support. So it's at some extent money received under the international loans are spent for trainings, but it is very low level. And for the question of Kirill about teaching FIDIC in the universities, some 4 years ago, I had a seminar in American University of Armenia. It was past very interesting. The people were interested, and I had some talks in architectural university about teaching construction law in the Architectural Institute for the engineers, but it ended up with this. But Irakli and Nino has given me a good idea about collaborating and trying to teach FIDIC in American University here in Armenia. If you have those courses, we can organize that, I guess. I think so.
Very good. I think it is a great initiative to proceed, not to stop, because Kirill Lanovenko initiated the same discussions with the local, very interesting, very big universities in Kazakhstan. Let's say significant, who have the significant power.
Kirill's experience also would be very valuable. We can discuss the same issue with Kirill.
Yes. This is the possibility to collaborate in future, maybe to have some common approach to the programs, let's say. And he's willing to make several programs. I'm trying to help him as well. This is very interesting. Good. For the listeners, please, if you have something some connections with the universities, please connect us in your country. If it is Georgia, then Irakli, you know, if it is Armenia, then Karen, if it is Kazakhstan, then me. And if you have contacts, Kirill, please, I think we are welcome to people who can help us with this. The fifth question we have here is, would be interesting the speaker's experience in delay damages topic. Again, the topic is huge. Irakli, maybe you will tell us some experience briefly.
Okay. Delayed damages topic. It's also, as I thought, for the variation issues. I can give lot of examples. Basically, what is the delayed damages? Delayed damages are the only possibility from the employer side to recover his losses. Delayed damages applies, if we go theoretically, the delayed damages applies on the contractor in case of he does not complete the works on time, and it cannot be more than 10% of the whole contract amount, and the time for completion or the delay period is 100 days until the delay penalties will not reach the 10% of the contract amount. So what the experiences do we have? We do had several complicated cases as well, as we was the parties, Nina, as I remember, on the contractor side, yes, on the contractor side, that there were delays. There are several types of delays. There are like concurrent delay, there are numerous. And what is the delayed damages? The result is giving the penalties to the parties. So I don't know what specific I can say for the experience on that. That's a bad story. In case of you go into this delayed damages story, then it's a never-ending game from the contractor side, from the employer side as well. So then in case of from the client can just apply the delayed damages when the time for completion is not reached. So if there is any specific question on the delay damages that can be asked, then please refer to us on any matters. But the delay damage topic is quite a big sphere, where in our trainings, whereas Nina is the leading trainer, we have almost a half a day discussing this topic, how the delay damages should be applied, what's the preparation for the delay damages, what kind of letters the employer should issue before applying the delay damages. In case of the engineer or the employer will apply the delay damages, not the engineer, the employer will apply the delay damages with non-reasonable or will make any formal mistakes, let's say issuing, first of all, notice to correct. In case of without notice to correct or without giving the contractor a formal notice that he's going to be penalized or he's on the delayed damages period, then the employer might lose all his all his position or the rightful of applying the delayed damages. Nina, you may add something on.
Just wanted to add, indeed, it was a very interesting case that me and Irakli were involved in. I just wanted to add that in accordance with the new edition 2017, there is one additional ground for termination from the employer side connected with the delay damages. When the delay damages reaches its maximum, the employer is entitled to terminate the contract. This is one new addition to the 2017 version that wasn't directly mentioned in the previous versions. So this is very briefly on this huge topic.
Just a small addition from you, please. If you have seen any successful stories with the delay damages for the employer.
For the employer,
successful.
plenty of them.
What you mean successful? You mean that the employer
they got them. Yes.
Got it, of course. We do have that kind of experience. I will not say the company name. He was penalized and got the delayed damage.
But it's rare practice.
In real practice, yes, yes.
No, no, it's rare. It's not often happened.
No, it's not often, of course.
Okay.
There are not so many bad companies in the world, thanks God, that everybody, after every project, everybody should be applied on the delayed damages. There are sometimes on the construction project is like a marriage. One party is upset, the second party is upset, but at the end of the day, the project should be completed. Yes, it is a challenge. It's called like that way. So there are different types of delays caused by contractor, which are maybe in case of we go to the details and categorize the delays, there are non-critical delays, critical delays, excusable delays, non-excusable delays, and etc. So on the delay damages topic, it opens a door on a big and wide area that it's quite difficult to explain within so short period. But based on our experience, we had a delay damages accepted by the contractor, or he was forced to accept it because the payment, the money, so to say, is on the client's hand. And even though he had applied on the dispute board the question that he was not entitled to pay the delay damages, even though the contractor has lost. We had an experience that we have applied the delay damages, so to say, or the employer had applied the delay damages, so to say. And after the decision of the dispute board, the delay damages was not, the contractor has not to pay the delay damage. I mean, the responsibility of the delay of the non-completion of time, non-completion on time, it was not attributable to the contractor. So it was the employer's fault that the contractor could not complete the works on time. So anyway, the employer had applied the delay damages, and at the end of the day, contractor got it back with the interest rate. There are different types of experience in the market, but mainly, thanks God, in Georgia, we do not have so many projects that the employer is applying the delay damages, or we do not have so many projects that they are under delay, so to say, more or less.
Okay, and the final question within this fifth question to Nina. Nina, legally in Georgian law, is it possible to apply delay damage? Because in Kazakhstan law, it is only penalty and that's all. In Georgian law, is it?
There are no contradictions in Georgian law regarding the delay damages. It's upon the parties' agreement. So you can agree on this in your contract, and it's the parties' agreement.
Okay, good. Karen, in Armenia law, is there any restrictions to use delay damages or?
No. So it's I especially check this because
it is possible to use it.
Yeah, when I was working in Kazakhstan, and then I came to this problem that delay damages are
impossible to implement.
Not very much applicable. So I've checked for Armenia. And remember my presentation in London, the things in the FIDIC which are not impossible to implement in Armenia. So this topic was forced to me to choose. I would rather choose another one, but for this one, I will hardly find something in Armenian law which is contradicting FIDIC.
Thank you, colleagues. As you can see, we have a lot of discussion on any question because FIDIC theme is very deep one, and you can dig in any field and you can go deeper and deeper. That is why we have decided to make an offline networking session in Dilijan. It will take place in April 29 this year, almost after months. This city is located, as who do not know, but for me it was new, but for you it's not news. But anyway, if some Kazakhstani people looking at this right now, or from Uzbekistan, you are welcome. Kyrgyzstan, Tajikistan, you are welcome, please. This city is a beautiful city located between Tbilisi and Yerevan, 2-3 hours by car. we will discuss the experience with the EPC and FIDIC in post-Soviet Union countries. This will be my presentation. Then Nina will share her experience about the FIDIC certification programs, how to get the adjudicator, how to get the trainer certificate. It will be the from the first hands from the person who got it. Then Karen will tell about the FIDIC in Armenia, future and experience. And the most interesting thing, we are going to initiate the process of making Armenia as a FIDIC member. The Union of Construction Consultants of Armenia, with support of Georgian Association of Consulting Engineers, who colleagues are here, thank you very much, initiated the process of making Armenia a FIDIC member. Our event will also be devoted to this goal, and we intend to involve the participants of the event to that process as well. That is why you are all welcome, more than welcome. If you want to register, please follow the QR code you have here. Also, I've sent the link in the chat, or you can connect directly with the Karen. His contact is here as well. Please welcome. So we have around 10 questions, maybe plus minus 2, 3 to answer, and let's go ahead. Karen, you want to add something? Sorry.
Yeah,
sorry,
I want
please.
to add something about this event. So Armenian participants are welcome. Georgians are also welcome to participate in our association. Just remembering that I am a member of Georgian Association of Construction Managers, so I would like to have Georgians in our association. So please, waiting you, we have to make Armenia FIDIC member.
But we are waiting for nearby countries as well. Everybody is welcome, because this will be very interesting networking of the FIDIC involved, very much, let's say, willing to share their experience people. You are seeing them here, first of all, and this will be very interesting to meet.
We are happy. I will add also on that event. We are very excited to come to Dilijan. We have heard a lot about this city. As I know, it's quite beautiful. It will be a nice opportunity to network. It will be quite easier and nicer to speak to face, exchange experience on the FIDIC contracts and etc. And I'm so very much excited that Armenia will become the FIDIC member as association. And as for from Georgian Association, we can guarantee the full support and the guidance on how to become and what we need to do to develop the association. So good luck on that, and looking forward to meet you in Dilijan.
Okay, good.
See you guys. See you in Dilijan.
Okay, we are going move on the 6th question. Is there any method you can recommend for the application of subclause 12.3b of FIDIC Red Book 2017? Irakli?
So, Nina, you may start, please, and then I will follow.
Nina.
Yeah, thank you. If the person who posed this question maybe want to add something, because it's not very clear, or like what kind of method we can recommend for the application. It
is Burak. His name is Burak. Maybe Burak is here from Turkey. Please.
I think no.
Okay, no.
No.
Not this time. Okay, no. Next time maybe.
Yeah. Oops, there is something on the display.
On the display?
Yeah.
By mistake, maybe. Oh.
If the person here, I just introduce the topic, what is about and how I understand the question. So Under 2017 edition, 12.3 subclause is regarding the evaluation of the works. And this particular paragraph B comes from the method of how to calculate a new rate or price in case of the variation. So there are, so this paragraph B have 4 different criteria when the new item may be applied. So the first one, if the measured quantity of the item is changed by more than 10% from the quantity of this item in the BOQ or any other schedule, if the schedule is applicable to the contracting set of the bill of quantities. The second criteria is that this change in quantity multiplied by the rate or price specified in the BOQ or other schedule for this item exceeds 0.0% of the accepted contract amount. The third one is that this change in quantity directly changed the cost per unit quantity of this item by more than 1%. And the final one is that this item should not be specified as the fixed rate item in the BOQ. So this 4 of these criteria should be satisfied, and in such case, the new rate can be applied. So Irakli, maybe you can share something from your experience.
Yes, thank you for the explanatory, Nina. Changing the rate, that's the most key wording on this matter. It doesn't always be that the unit rate for the contractor interest is always to increase. For the employer's interest is always to decrease the unit rate. So this, in case of this, all 4 criteria has been satisfied in the contract. It doesn't give you guarantee that the unit price will be increased. It's quite a tricky issue. For example, it depends on the type of the works. In case of, we are speaking about earthworks right now, and you have a huge variation over, and it doesn't really, and the works has been already considered in the contract, and you are satisfying these criteria. For my example, there was an issue case that the employer, not the engineer, had made a determination, had deducted the unit rate, because the contractor, with explanatory note that the contractor is receiving more profit in the unit rate, and he doesn't apply any additional measures, any additional, so to say, force that he would complete these variation orders. But he was receiving far more profit on this matter without the procurement rule. So it's always a big depends. We need to look at that subclause on a specific matter, on a specific, so to say, situation or the event, what is happening and why this, what kind of work, what is the type, do the contractor need any additional forces to complete on it? So in general, these subclauses, Nina has explained this. We have a lot of experience on applying that procedure, but what I can assume and say shortly, it doesn't always so guarantee you this subclause that the unit rate will be increased. It may decrease as well. So that's a short comment.
I will tell you, you have very good, better approach in legislation than us, because in Kazakhstan there are all those stated items are almost all of them are restricted by laws, if it is financed by state financing or by international financial institutions in favor of local company owned by state. It's the same as the budget money, and there are 4 different approaches and 4 different rules depending on the ownership of the company. Samruk Kazana, oil and gas procurements, state procurements, and there are separate rules for all state-owned companies. And it is possible, for example, just what is possible and what is written in such rules. It is possible to apply any variation related to contract price in some certain ways prescribed by special rules. Increase should be only in costs because of the market price change on 10% and more. Subject no any changes in design. In any other way, any changes can be allowed after passing special, very much regulated procedure, like a design state examination procedure, which is over-regulated, as I've said, and allowed to do only once or twice during the construction period. This brings the headache to make any changes in the contract price during the construction period because of the changes in units and in something else, and it's headache for Kazakhstani based projects, for example. Yes, thank you very much. Let's move on.
You know, Andrey, I also have experience with Kazakhstan in changing cost. Yeah, it was not changing cost, but it was connected with variation. So engineer asked for variation, proposal for variation, and they forced us to put some special prices in variation. It was very strange. So yeah.
Yes. Sixth question. Yeah, obtaining decisions, licenses, and permits. What can be demanded of FIDIC contractor unless under clause 113? What about fine imposed on the employer by the administrative body and regression request? Yes. Who can answer? Nina, I believe.
Yes. I believe the person is not here, right, who posed this question, so I will be short on that. So this question has two sub-questions. So starting from the first one, what can be demanded from the FIDIC contractor under sub-clause 1.13? So first of all, to explain what this clause is about, it's about the compliance with the law, that the contractor is obliged to comply with the applicable law. So we all know that the FIDIC contracts are not in vacuum, that all of the FIDIC contracts are governed by the applicable law. It may be Georgian law, Armenian law, Kazakh law, and whatever the parties may agree. So the very simple answer to this question is that the compliance with the laws can be demanded from the FIDIC contractor under this sub-clause. What is interesting about this sub-clause in the new 2017 editions, that it is explicitly stated that if there is no reasonable assistance from the employer to the contractor to have the permits, licenses, and any kind of an administrative stuff, and the contractor suffers from this event, there is a ground for the claim. In the previous editions, in the 99, it was not so explicit. It was that the sub-clause 1.13 was not explicit ground for the claim. This is just a very brief outline of how the new edition came up with this matter. And regarding the second sub-question, what about fine imposed on the employer by the administrative body and the regression request? I would say that it will depend on why the employer was penalized by the administrative body. So, for example, if it was because the contractor did not comply with the applicable law and the employer is penalized because of the regulations of the law, then of course the employer can, by regress, demand this penalty to be compensated by the contractor. But if, for example, the employer was penalized because of its own actions, because of the non-compliance with the applicable laws, of course, the contractor cannot be demanded of this amount by regress. So that's why it would be very interesting to hear from the person, but if she is not here, we can move on the next question.
Thank you very much. Good. The next question is, if the employer has submitted the site handover certificate to the contractor 1 year after notification of the work start date. From what date will the work completion date starts? It was in Russian, I just translated it by Google Words, but you remember. Maybe the author is here, I believe.
I think author is here. Sergey, we can see you.
Sergey, you can put your mic on. Добрый день.
Добрый день.
Доброго дня всем.
Может быть, чуть-чуть дополните свой вопрос, то есть о чем речь еще раз раскроете нам?
Так, ну суть в чем заключается? Инженер выдал уведомление о дате начала работ, всего лишь, скажем так, не используя все 4 пункта, которые перечислены в статье 8.1. То есть подрядчик в свое время на это не отреагировал, он начал работать, а потом спустя некоторое время он очнулся и говорит: ой-ой-ой, а мне еще по 3 остальным пунктам не предоставили данные, и поэтому я считаю, что дата начала работ, она является недействительной. Как быть в этом случае?
Нина, сможете прокомментировать?
Да, я не знаю, наверное, я лучше на английском буду, чтобы всем
It is better in English, I believe, yes, because initially it was in English.
Okay, sorry.
No problem, I understand.
The question, so for everyone to understand the question that was asked by Sergey, so under the new edition to 2017, there are certain conditions for the notice to commence to be issued by the engineer. So one of them is, for example, the DAB to be appointed by the parties, because as you know, in the new editions, it's standing DAB rather than the ad hoc that it was in previous version, like it worked in the practice. So the Sergey's questions was that what happens if the notice of commence was issued by the engineer, but these criteria that are listed in the subclause are not satisfied fully. And the contractor started the work despite that these grounds were not satisfied, and after 1 year decided to raise the question whether the commencement date is valid. Me and Irakli had the similar case when it was also 2017 Red Book. As I mentioned previously, one of the preconditions of the notice commence to be issued by the engineer is the appointment of the dispute board. And the dispute board was not appointed in this regard. And we were acting on the side of the contractor, and we also had the same idea as Sergey mentioned, that what about how to state that the notice that the commencement date is not valid. We have not tested it in practice, but I firmly believe that this may be a good legal argument to state that if the condition, how they are stated in the subclause are not satisfied, the notice of commencement that was issued by the engineer is not valid, and therefore the commencement date is not also valid. So if, for example, there is a delay by the contractor, for example, let's say the contractor's culpable delay, it may be argued that there is no delay since there was no valid commencement date. But I would say that it is very complex legal arguments. In theory, they may be developed, but it will depend on the circumstances of the case.
Irakli, do you have something to add?
I do fully agree with Nina, because as she mentioned, we had that kind of ideas as well, trying to find it out. So in practice, I don't know yet because we do not have any examples doing this. We were, so to say, first in Georgia trying to challenge this issue. So as Nina has mentioned, it's a really big, complex case, legal case. So we look forward how it will be ended. We will share that our experience within a couple of months, I believe so.
Good to know. Karen, maybe you have something to add here.
So we were planning that I will add to the question which is related to this. Remember that?
Yes, we have one related to this commencement without the full LARP implementation. It's something like this, related to 8.
Yeah. So why we decided? So first, let me explain what is LARP. LARP is Land Acquisition and Resettlement Plan, which is for some, which is compulsory to prepare and to implement on the international financing projects. When the project is shall be put on lands which are not owned by the government, and they first shall to buy those lands, and this is LARP, so the Land Acquisition Plan. So these are, I've came to this problem in Armenia and in Kazakhstan when it is mainly related to big linear projects for pipelines, channels, and roads. So one of my experience with roads in Armenia, the other one with channels in Kazakhstan. So so commencements have nothing to do with LARP implementation. So FIDIC says nothing about LARP. It says only about giving right of access to the site. And it says that the access to the site shall be given in full. If it shall be, and if it is not, if the right of access and if the employer has not yet all the rights over the site, it means it cannot give right of access. It means that he cannot give right of access to fully for the site. Okay, they may agree, the contractor and the employer, that the right of access would be given part by part, and but it shall be written in the agreement. Shall be written, and anyway, this timing of giving right of access to the parts of the site shall not be in contradiction with work program, which is prepared by the contractor and which is accepted by the engineer and, let's say, by the employer. And this is the problem. And if LARP implementation disturbs to give the full right of access, then it shall be it shall be risk of this is on the employer. The contract says the right of access shall be given in full, even if the parties agreed for something else, not in full by part. Anyway, this timing shall be kept by the employer.
Okay, thank you. So next question. Ninth question. What will be exact procedure after dissatisfaction with DB in FIDIC Yellow Book contract 1999? Nina?
Sure. So, in accordance with the FIDIC Yellow Book 99, if either party is dissatisfied with the dispute board's decision, then either party may, within 28 days after receiving the decision, give notice to the other party of its dissatisfaction. It's under subclause 20.4, that is called obtaining dispute board's decision. There are certain formalities of what this notice of dissatisfaction should mention. I will not stop on this. The next step after the notice of dissatisfaction is given is the amicable settlement. So under 99 version, under Yellow Book 99 version, the period for the amicable settlement is 56 days. And after, if parties could not agree during this period, then the arbitration may be started. So this is procedures after the notice of dissatisfaction is given. Just to add small thing about this, if the notice of dissatisfaction is not given within this particular period of 28 days, then the decision of the dispute board shall become final and binding upon the parties. This is the whole procedure of the notice of dissatisfaction with the dispute board's decision.
Irakli, do you have something to add?
Actually, Nina had talked detailed on this matter. I don't have anything else to add.
Good.
This is the formal procedures, how you need to go forward.
The next question, how is wide and developed the market of EPC contractors in Armenia and in Georgia? What significant project had been realized basing on EPC contract strategies for last years? Nina, on the Georgia?
Very quick comment on the EPC, the main projects that are developed in the Georgia are mainly the hydropower plants. This is the experience for Georgia. I cannot really talk about the names of projects, but most of them are the HPPs.
What about contractors? What about EPC contractors? They have a lot of EPC contractors experience, or dozen, several dozen.
Not a lot of local EPC contractors, I would say.
The most of the contractors are foreigners.
Foreigners.
Yes, mainly the main EPC contractors are foreigners. So there are a couple of Georgian EPC contractors as well, in the field of energy mainly, wastewater treatment as well. That's the
most significant project realized.
Karen, what about Armenia?
I'm terribly sorry to say that I do not see any EPC contract in Armenia. Probably there, we have no, I would say. Even if we have, I don't know about them. They are so.
Not so much.
Yeah, and I know the problem is not only so Armenia is small, but problem is that mainly the issues that countries solve with EPC contracts are solved here in Armenia. We do not have water power plants here. We do not construct new power plants here because we do not construct nuclear power plants here because this Armenia is fully efficient with this, and we have even exporting our surplus of electricity. The same with water treatment, but I hope someone in the nearest future we will start to construct, let's say, factories with EPC contracts, but we do not have experience here with EPC contracts. Well, we have just a couple of years ago, there was a contract for the construction of Yerevan thermal power plant, but it was not EPC contract. It was a contract with PPP contract. Yeah, it is more or less EPC, but it was not the full. It didn't have full book of EPC contract.
Okay, I see. I will add something from Kazakhstan just because I'm here. In Kazakhstan, it's different. I mean that almost all of the contracts are EPC, except for infrastructure, roads construction. Usually it is red books. But everything else, factories, plants, buildings, different kind of energy projects, power plants, They are all EPC. Yellow book turned to EPC, silver book, but there are, of course, problems with this because EPC, but with the low price. That is why a lot of issues with the price escalation in a year, in a two, and so on related with that. And we have, as in Georgia, only a couple of local EPC contractors who are well, but not in everything, let's say. Usually it is consortiums with the foreign contractors or the foreign contractors in Kazakhstan. Okay, next question. We have not so much left. 11. Could the construction of nuclear power plant be the subject of FIDIC? I will start. Yes, it is possible. It is on practice. It was used dozens of times. For the last experience I've heard of about it is the I don't know how to say in English, kupol, like the covering the Ukraine project. Let's say it was built under the FIDIC contract. The dome. Yes. Maybe Irakli or Karen have something to add here.
As you have properly mentioned the example, I do believe the most sufficient contracts constructing that kind of infrastructure projects is FIDIC. From my point of view, is the best solution on this matter. You can use different types of contracts for the construction of the nuclear power plant. You can use silver book, turnkey, or any other contract. So I do believe it matches perfectly with the FIDIC's conditions of contracts. This depends on the employer, which type of the contract will be chosen, of course.
Yeah, just to add very briefly, and I also can share the link in the chat. Even the world's largest Hadron Collider in Switzerland, in CERN, is under the FIDIC book. So
based on okay, good example. Yes, it is possible, and on practice, it is happening.
I will add. I know the person asking this question. So, yes, construction of nuclear power plants. So there is a special contract in FIDIC book suite. It is silver book, specially designed for this type of project, which were the projects which are intended for producing something. These are power plants, doesn't matter nuclear or other type, or factories or whatever. So the construction of producing means. This is silver book of FIDIC.
Okay. Next question. Thank you very much, colleagues. Adoption of MLITER. Yes, we wanted to give a possibility to the author of this question to turn on the mic and tell us what does this mean. If the author is here, please turn on your mic. If not, we will answer the last question. Are there any translations of FIDIC books to Georgian? How and on which projects they are used? Nina?
Well, I will very briefly speak about it. So, so far in Georgian, FIDIC Red Book 99 is translated. It was translated and presented to the public back in 2017. As the association, we have plans to have more translation, especially the Yellow Book and the new editions, 2017. In this year, also we have plans to translate the Green Book. So these are the plans of the association currently. About the second part of the questions, how and on which projects they are used. What we know from the association and also from our private practice, the translation is mainly used as the reference as the reference point for the FIDIC contracts, because the majority of the FIDIC contracts that are in Georgia, that are operable in Georgia, are made in English. Mostly the reason of this is because it is financed by the multilateral development banks. But from what I have experienced recently, the large developers start using the FIDIC contracts on their private projects as well. For example, for the multifunctional complexes and for residential buildings, for office buildings as well. I am not aware of any particular example when the FIDIC contract in Georgian was concluded. I was very near on that, but unfortunately the employer decided on the bespoke contract. But I hope that there is a huge market for that, and the good thing is that the private companies also understood the importance of the FIDIC books for their projects. And I believe that in the next few years, we will witness the use of the FIDIC edition in Georgian as well for the contracts, and not only as the reference point for the English FIDIC contracts.
Nina, is it possible easy to buy these books in Georgian language?
It's so the printed version can be purchased from the association website. It's ACEG. I will add the link in the chat. And the electronic version that is used for the contracts can be purchased directly from the FIDIC bookshop, so fidic.org.
Good, thank you very much. Karen, about Armenia, do you have something in Armenian?
No, for sure. So this was my question. So why I ask this, because I'm going to translate a couple of FIDIC books into Armenian when we become FIDIC member. I hope that we will translate and we will use it. So it was very interesting. But did I understand correctly, Nina, that the Georgian version is used only just for those who not very much good in English, just for reference? They use officially as official one the English version, and use Georgian as a help for those who cannot understand.
Yes, this is the major practice of what I know. And I also mentioned the reason because the majority of the FIDIC contracts so far are for the international infrastructure projects, where the contractor is mainly an entity. Yes.
But as Nina mentioned, for the international projects of financing, the Georgian translation is an addition, so to say. But the English version is the must. But based on our information in the local market, so the private developers, they start using the translated version of the FIDIC Red Book.
I understand that,
because we have sold a lot of books in the Georgian language or the FIDIC from our association, the hard copy. So we know that some of them are using the Red Book in a Georgian language on the private sector, more or less.
I see, but for the using of Georgian version as an official one, but I don't see any so much sense in it, because the usage of FIDIC, people want to use FIDIC to attract foreigners. You have to attract foreign experience to their country, to make the tender open to everybody. Yeah, this is the meaning of FIDIC. But by choosing a language, the employer narrows his choice. Isn't it so?
Sure, but for example, if both developer and the contractor, for example, from the example that I know, are both Georgian entities who speak Georgian perfectly, why they should bother having the contract in English? So it's just additional weight for them to have the contract not in the native language.
Yeah, so you know, I have an experience here that we have organized an international tender, and FIDIC red yellow 17, and it happens that the parties all Armenians. But it was international tender, and we used English version, of course. And
Yes.
we have signed English contract, and I don't see any problem with this.
Yeah, I think that the national translations of the FIDIC books for the small countries like Georgia or Armenia can still work, not only as a reference point, but also for the actual contract as well. But the main purpose of the translation for the small countries, I believe, is still the reference point.
I do fully agree that doesn't really matter the size of the country or the people using the amount. It's still necessary to have the translation in the language, because whenever in the contract implementation period, for example, the project manager, he definitely speaks English and he definitely read that in English. But there are, so to say, other specialists involved in the construction process, like Georgians, maybe, or site engineer, or any other engineer. They should as well understand the FIDIC contract. They should at least know some of the basics of the contract, that they will give the correct information to the project manager, to the employer, and etc., etc., etc. So you cannot require from all of them to speak English language, that you have proper operation of the contract. So we do believe that, and as we see on the practice, that then there is a necessity of translating that books. At least you will understand the correct terms. What we have saw in our practice, let's say from one ministry, they have translated by themselves a book, and they have added as a advisory document. Yes, there was a contract in English and there was a translation of that contract in Georgian. So then all of a sudden some disputes arising because the contractor's employees was thinking that the wording in the Georgian language translation was correct, and coming out of this idea, then there was some disputes and misagreement and the disagreements and etc., misunderstandings. And the other minister, they had translated by their way. So there was a lot of mixtures, yes, in the ministry. So what the association has done, they made the official translation with a certified experts, and everybody now is using as a copy the Georgian translation. In the private sector is directly the Georgian translation book signed and so to say implemented. So that's the reference, to avoid a lot of misunderstandings between the international contractors and the employer side, because the employer side, not all of them speaks English, yes, only there are some of them, like say 60%. But what about the other 40%? They should as well understand that. So there comes the translated book, officially translated with the correct wording, because there are a lot of wordings during the translation that Nina and our ex-president Daduna has done. It was a huge job consulting, because there are words that you can translate in Georgian. So let's say claim, you have 3 or 4 different wordings for that claim. Which language you choose, the aggressive, the passive, and so on and so on. That's a huge job. That's a huge job that you need to do, which the association, with the previous management of the association, has done. And Nina is here presented on the translation one. So we are working on it. The terms new terms has to be adopted in every language that the book is translated. This is also quite difficult matter and quite serious to consider on it.
Yes, so you said that there should be a custom of using FIDIC terms in your language. So you know, I'm against of using translations as official ones. As reference, it works well, but for translation, I afraid, because for example, with Andrey, we often use Russian translations, and always we come to some let's say mistranslation. So it is even not mistranslation. For let's say a term is very good in this clause, but the same term in another clause is may have another meaning.
Yes.
So even you know that story that word claim has different meaning in different English-speaking countries. So it is even using English version can bring to misunderstanding.
But using English version is more common practice, and it is easily to prove that claim means claim, this or that. When we are using our local languages, it is always the traditional, the history, and it differs. It differs, and not so much practice using the local language. Lack of this. In Kazakhstan, this question even never risen. I never heard about somebody who wanted to translate it to Kazakh yet. Maybe in future there will be, for sure. I think this approach, translating to national language, is the way making the FIDIC more popular as well. I mean, because locals, there are a lot of locals who knows English so-so, working with the English-speaking people, and it's enough. But when they are facing with the professional English language, especially with the construction field, then they would need to understand it properly, and then the proper translation should help, should assist, should help people to manage it and to ask, maybe to start to ask proper questions. And that is why national language, having the translation for national language, will allow country to bring these contracts deeper and maybe better in understanding. This is all questions. Thank you very much. No questions in the chat yet. I want to thank all speakers again for your participation, for your answers, and for your support with the event we are going to make in Dilijan in the 8th of April. Again, I'm remembering about this event. You can register following the QR code. You can contact with Karen if you want to participate. We have only 30 days left. It's time to book the tickets. Who want to fly, who want to drive, who want to come by train. I do not know trains goes to Dilijan or not, but anyway, Dilijan is very easy accessible. Have easy access to Tbilisi or Yerevan by car, and we are all welcoming all of participants, all of listeners, because we will post this video on YouTube. And maybe final words from lectors or from speakers, please.
Thank you very much. I hope you enjoyed the session. Thank you, and hope to see you in future in Dilijan as well.
Thanks for the participants. Thanks for the questions. Thanks for the answers. And hope to see you in Dilijan. And also Kirill is listening. Ask Kirill, I would like to talk to you and to discuss with you, Nina and Irakli, your participation and our participation in American University of Armenia. I guess we can do great job.
I want to say thank you as well to all participants. Thank you very much for being and listening to our session. We would really love to have that kinds of webinars. Any further questions, we do look forward to discuss that in Dilijan. I'm really excited to go there and to see you live. That's amazing. If any participant had any questions or anything that we can shortly advise, We will post our posts on LinkedIn. They can contact us or find us in LinkedIn and have a, so to say, discussions on any matter that you would like. So we'll try to put it on the chat, our LinkedIn's. Nina, maybe you can assist. And see you soon in Diligent.
Thank you very much, colleagues. See you soon. And
See you.
we'll wait for some comments maybe from the listeners. Thank you very much.
Thank you. Bye-bye.
See you. Bye.
Bye-bye.
See you. Bye-bye.